Greetings, everyone. I would like to welcome all present here today from across the globe to the sixth day of our second International Virtual Mediation Summer School organized by Nivaaran. I am Reema Bhandari, a mediator from the Supreme Court of India, and I'm honored to be the host for today's session. Nivaaran is a body of Supreme Court mediators of India that endeavor for the advancement of mediation globally and has also conducted various webinars internationally to achieve this goal. Following this ambition, we have already conducted 5 classes on various aspects of mediation, wherein eminent speakers across the globe have provided invaluable insights on historical perspective of dispute resolution, definition and process of mediation, difference between mediation and other forms of ADR, conflict management and resolution, communication, and negotiation skills. Now, adding another star to our constellation, let us begin our session on the core of mediation, that is ethics and its various components. Now, I would like to invite and warmly welcome Mr. Yong from Singapore Mediation Center, a graduate from the University of Warwick. He is the Registrar of Supreme Court International, is the Registrar of Singapore International Mediation Center and is responsible for the administration of the cases filed there and implementation of SIMC's mediation rules. He has also worked in international boutique firms, focusing on cross-border structuring and insolvency matters. He thoroughly believes in the concept of mediation and has a keen interest in helping businesses achieve commercial objectives through mediation. It is an honor and privilege to have him here with us today. We are extremely grateful to him for introducing us with another eminent speaker for today's session, Mr. Siddharth Jha. I want to welcome Mr. Siddharth Jha today. Mr. Jha has graduated from NLU Gujarat and holds an LLM in dispute resolution from Pepperdine University School of Law from US. He is the center manager at the Singapore International Mediation Center and oversees the development of international mediation in India and the South Asia region. He is also proactively involved in the furtherance of mediation and has also worked in the Bombay Chamber of Commerce and Industry, focusing on development of their mediation center. Well, coming to our topic for discussion today, that is ethics in mediation. I would say it can be well illustrated by a quote of Aristotle that by educating the mind without educating the heart is no education at all. Now, the expansive world of ethics consists of standards of behavior our society accepts and help us to differentiate and recognize right from the wrong and good from the bad. Honesty, loyalty, integrity, compassion, selflessness, there are various values which guide us throughout the familiar turbulence which we face in our daily lives. Ethics play and I would say an extremely important role in resolving legal disputes with a far greater space. Mediators always have an ethical duty to foster an atmosphere of trust by maintaining confidentiality, neutrality, and self-determination of the parties. Although this seems effortless on the surface, it is far easier said than done. Engaging and making substantive change is far more arduous in application when people's livelihoods are at stake. The predominant reason for this difficulty lies in our core dissimilarities. These can be our perspectives, cultures, mindsets, and circumstances. This complexity presents us with many combinations, which is the exact reason I would say this topic is so important for our class today. Though while ethics should be followed by both, that is the parties and the mediator, but it is the mediator's duty to uphold the integrity and fairness in the mediation process. So our mediator should ensure that parties are fairly informed and have adequate understanding of the procedural aspects of the mediation process. He should disclose any interest or relationship with the parties to establish his neutrality and impartiality. He should be faithful to the trust and confidentiality reposed in the office of mediator. He should maintain confidentiality and refrain from giving any promise or guarantee of results. He should recognize that mediation is a self-determined process, meaning that the mediation process relies upon the ability of the parties to reach a voluntary agreement. Despite following the ethical principles very diligently also, mediators face the dilemmas that can only be explained by some hypothetical situations. For example, in a dispute, when a mediator comes to know that one of the party is only interested in gaining more time and or to know what the other party is having in their mind, to know their strategies. And once in a separate session, a mediator gets to know about this, what should a mediator do? We will be discussing more hypothetical situations later on in our panel discussions. But I would say these hypotheticals are only food for thought. There are numerous situations that have not been imagined and can still occur in the mediations. Well, I am discussing these hypotheticals today to help you understand the dilemmas faced by a mediator and to understand the significance of ethics in mediation. Confidentiality, neutrality, and self-determination, which are the basic core of mediation, and I would say are the dimensions of ethics in mediation. They are the primary principles and can be even classified as the jurisprudence of mediation. Confidentiality, I would say it lays down the foundation for an honest and candid disclosure by the parties. It amplifies the integrity of the mediation process. Confidentiality strengthens one's level of trust between the parties and the mediator, and it fosters honest and truthful communication by which parties are able to disclose their confidential concerns and strategy to the mediator without any inhibition. Now, mediator ensure confidentiality how? It can be done by familiarizing the parties with the ground rules of mediation in the opening statement by informing them that the mediation will occur behind the doors. Publicity is prohibited. Mediator will not record the details of any deliberations and will never disclose any information without their prior consent. And mediator continues to maintain this element of confidentiality in all the stages of the mediation process. He can start it with the opening statement, but it carries on in all different stages of mediation, which can be separate session, joint session, and all. Coming to the second important component is neutrality. Neutrality establishes fairness and I would say an inevitable ethical principle that embeds itself in the core fabric of the mediation process. It is universally revered as the heart of mediation process, and it encompasses issues such as mediator acting as an antidote against any kind of bias, mediator not having any personal interest in the outcome of the dispute. He should not have any prior knowledge of the dispute or any connection with the parties to the dispute. He should not be judgmental, but definitely a person with an open mind understanding their issues. Now, a mediator maintains unbiased relationship with disputants by displaying neutrality in different ways. For example, by appropriately utilizing his body language and self-monitoring skills, by giving equal time and turns and opportunity to both the parties. And most importantly, the mediator keeps his own perception in check and concentrate on upholding an open and honest perspective. Coming to the third important component, that is self-determination. It is widely regarded as a focal concept and an essential value and holds an essential value in the mediation concept. It is the act of coming to a voluntary, uncoerced decision in which party makes free and informed choices with regard to the process and outcome of mediation. It sets mediation apart as a unique and a special process, as the mediator role is to use his expertise to enable them to reach their own decision. The decision is of the parties only, and mediator only facilitates or helps them during the process and enables them to self-determinate their concerns. The mediator only acts as a vehicle to the resolution, and the disputants are the one that directs the vehicle to the destination. It promotes greater respect for the effectiveness of the mediation process, as disputants play a significant role by directly interacting with each other. Self-determination generates principal and legitimate settlements, as it highlights the parties' involvement and collaborations in the negotiation, option generation, and decision-making components of the mediation. Thus, I would like to say that self-determination is the key factor which distinguishes mediation from litigation and other different kind of areas. Now, after giving a brief intro about our topic today, I would now like to hand over the reins to Mr. Yong and Mr. Cha, who will elaborate on the basic principles of ethics in mediation. And Mr. Yong will not only expound on the importance of ethics in mediation, but will also delve into the role of Singapore International Mediation Center in maintaining the integrity through upholding and fostering ethics. He will also tell us about the various important articles of the Singapore conventions with regard to these components of mediation. So as it is decided, I think first Mr. Jha is going to speak on the basics of mediation today. So over to you, Mr. Jha.
Okay, go ahead.
Okay, thank you very much, everyone. And thank you, Reema, for the very kind introduction. And good evening to everyone, esteemed guests and friends. We're very happy to be back here again. My colleague, Julian, was here for the summer school last year. And we thank you very much for giving us the privilege to do this, sharing once again with summer school. So we'll, as mentioned by Reema earlier, we'll be going through three main chapters in our presentation today, starting with the basic principles of mediation ethics, followed by the importance of ethics in mediation, and then finally, we'll also share our role as a mediation center in maintaining ethics. So I'll now pass the time to Sid, my colleague.
Thanks, Shikai. And thanks, Reema, for the kind introduction. Grateful to the organizers for inviting us again. Hi, everyone. I'm Siddharth, and I'm here to talk about this interesting and one of the most important topics, ethics. So I'll just quickly take you through some general principles of ethics, which is one of the most important pillars in a mediation process, as Reema also pressed on. Request you to listen carefully. You might find me a bit accelerated. That's just in the interest of time. We have a little much to cover with some case studies and conclude with discussions. This topic is vast, but our main intention is to make you focus on why ethics are important and how an institution such as SIMC makes it achievable through its high standards of procedures. I'm sure by now you would be knowing, what is ethics. It's a process of determining what one considers right and wrong decisions. It's not a simple task. It's a complicated task because, see, right and wrong are dictated by one's perspective, and it may vary according to culture, moral climate, and individual circumstances. What may be the right principle or action for one party may be wrong for another. Now, in such cases, again, I'm impressing upon on the fact that an institution always plays an important role because it provides a mediation services while also maintaining the high ethical standards. There's always checks that are present in an institution. So, as you can see, some general principles of ethics are such as confidentiality, neutrality, voluntariness, conflicts of interest, and some others. Next. So confidentiality. Now, like confidentiality basically helps in preventing the unauthorized use or disclosure of information. It ensures that only those who are authorized to access information can do so. It's like, confidentiality is actually at the heart of a mediation session and is critical to its successful resolution. The parties must be assured that they can share sensitive information freely, speak as candidly, as they could, without any fear of subsequent disclosure outside of the mediation. So that's the duty, that's the job of the mediator to get the parties into that confidence. It's basically like, if I can simply put, what happens in Vegas stays in Vegas. That way, confidentiality plays an important role both in joint sessions involving all the disputants, and as well as the private caucuses where mediator may have private sessions with the parties. So there also the mediator has a duty to maintain confidentiality. If one party has said, first, so there are two aspects. First, the mediator should safeguard that anything discussed in the mediation should not be known to any third party that is unauthorized. And secondly, when in a private session, confidentiality should be maintained in a way that if one party does not want the other party to know, so then the mediator should not cross the line. In that way, the confidentiality of mediation process is actually protected in varying manners. It could be case laws. It could be also, I'm sorry about the case laws, but it could be the mediation agreement signed. Okay. It could be a statute of law. For example, I think our section 75 of the Indian Arbitration Act, or there are also rules by the Delhi High Court rules on confidentiality of mediation. It can also be protected by a non-disclosure agreement. Now, again, an institution plays an important role here because it gives that infrastructure to maintain high ethical standards of confidentiality, its sense, and its genuinity. Shikai, next. Let's talk about neutrality. So neutrality, impartiality, it's self-explanatory. Mediator has to be neutral. That's the condition. So in mediation, I'm sure you all must know, and for the students who joined us, see, mediation requires a kind of engagement and engagement with the parties. And it's difficult to engage the parties without emotions being involved. We are humans. Mediators are also humans. They are bound to be driven by emotions. But the mediation should not be affected by that under any circumstances. Our words, manner, body language, the process management must reflect even-handed approach. So the idea is basically to not let your thoughts be affected by those emotions. And you have to be, of course, impartial throughout and without any prejudices. In case the mediator finds it difficult to be impartial, I think the best thing is to withdraw from the case. Next. Yeah, thanks. Voluntariness and self-determination. So voluntariness, basically, see, party autonomy is one of the guiding principles in any mediation. No one can be forced to mediate. It should come from one's will and voluntariness, and it should be respected at all the times. Yes, in cases some parties come to mediation because they're required to do so. Could be by a court order, or could be by law, or a dispute resolution clause. But in those cases also, they have and they must have a right at a certain point to maybe walk away from the table if they are uncomfortable, if they are not comfortable with the process. So they should be made aware that they have that voluntariness is so important in a process of mediation, that even before signing of the settlement agreement, if the party thinks that no, this is not I'm not going to be happy, this is not a win-win, so then the party is free to walk away. One more thing about mediators should support and encourage basically the parties to make their own decisions. In no manner there could be such situations where the party could just ask a question, what should I do? But the mediator's duty is to help the parties find their own answers, rather and actually should refrain from making any suggestions. In case there could also be situations where party is dominating the other party. So then the mediator should prevent that party, because in that case also, if one party is dominating the other, it prevents, and it's difficult for the party being dominated to make a decision, to make their own decisions. Next. Now, conflict of interest. Again, this is self-explanatory. The idea is basically to check if there is any kind of relative interest involved of the mediator. So mediators must avoid serving in cases where they have a direct personal, professional, or financial, direct or indirect, in the outcome of the dispute. This duty actually becomes more complicated when the mediator's interest is indirect. For example, the mediator works in a firm with someone who has an interest in the outcome, or could be related to someone who has such an interest. So in those cases, it becomes a bit complicated. But cases where the interest is indirect, the question is, how indirect is the interest? Is it simply a matter of disclosure? Now, how to check that? Obviously, in any case, it's the mediator's duty to make a full disclosure well in advance to the parties. If the mediator cannot fully disclose, then I think should decline the case. But I personally apply this simple test. I personally use this. I call it the headline test. If there is a conflict, I'd always ask myself, how would I feel about the potential conflict appearing in the front page of the newspaper? So it just makes the job easier. Yeah, next. Now there are some other principles that could be considered, such as competence, duties to third parties, and honesty. Now, competence and professional role boundaries is very important, because the mediators have a duty to know their competence or limits of their ability. They should avoid taking assignment, that they are not equipped to handle. If they do not have the subject matter expertise, they should disclose their degree of competence. They must also, it happens sometimes the court appoints a mediator. So in those cases also, if the mediator thinks that, he is not competent enough, he can, turn it down. There is also, must avoid, the mediator must avoid providing other professional services. For example, the mediators who may be licensed as engineers, therapists, lawyers should leave the parties to their, to others. They should not involve in that if they are a mediator in indulging with the party. Then there are duties to third parties. For example, the mediator also has an important role to check whether the mediator is not doing any harm to the parties who are not participating in the mediation process. Now, there could be, for example, some vulnerable persons or the public at large. For example, it's a case involving a faulty construction of a public project, such as a bridge or a highway. Then the mediator should at least consider about the third party, that is the general public. Then honesty, of course, it's the duty of the mediators to be honest all the times, among other things. Full and fair disclosure of their qualifications, experience, and every information that is necessary should be given to the parties. Also, it could also mean honesty, also means telling the truth when meeting parties separately. For example, when mediating separately and confidentially with a party in a series of private sessions, the mediator is in a unique and privileged position and he must not abuse the trust of the parties. Even if he believes that bending the truth maybe could further cause, further the cause of the settlement. Then there are some dilemmas, there could be situations where one comes across certain atypical situations. Those, we term it as ethical dilemmas. Now, to just quickly tell you what to do, when you face a tricky ethical dilemma in a mediation, you could either leave it alone if it's not bothering you much, or address it with the parties indirectly, directly, confront the parties with your dilemmas. Maybe you can take a break, seek an advice, of course, terminate the mediation and withdraw as a mediator, and report and take consequences. Now, it is important to note at this juncture, and as I said in the beginning, that ethics is the process of determining what one considers right and wrong decisions, and everyone has their own perspective, right? So how does one ensure that there is a standard that is being followed? How would one ensure about atypical situations? That's where an institution like SIMC steps in and raises the bar. Because see, it deeply follows the ethical principles, and the parties involved get assurance of the parity and high standards of ethics and best practices. But yeah, like my colleague Shikai will now take you further with the importance of ethics and SIMC's role in maintaining the standards. Thank you.
Thank you very much, Sid. So now I will go on to the second part about the importance of ethics in mediation. And if I may refer you to a recent event that was held, that was organized by SIMC together with partners in India. This was the India-Singapore Mediation Summit on the 17th of July recently. And the key thing to note here is really that there was an unprecedented sharing by the Chief Justices of the two apex courts. And among the key messages that were delivered by the Chief Justice of India was that it is really now the best time to make mediation mainstream and accessible for everyone. The other key message delivered by the Chief Justice of Singapore was that with the signing of the Singapore Convention and the ratification by countries, it is indeed the golden age for mediation. And I'll draw the relevance later. I'll share this part of the speech by Chief Justice of India to the importance of ethics.
This is also brings to another important factor, the need of ethical standards, unimpeachable integrity and neutrality of the mediators. As I mentioned earlier, a more active involvement of the mediator in the process of mediation could open the doors to parties attempting to influence them. This necessitates the creation of an environment which prevents any such attempts being made by any unscrupulous party. It requires that mediators be of good character and moral standing. For this, it is necessary that rules and regulations governing mediators are updated and implemented to ensure transparency and neutrality.
So I couldn't have explained it better than showing this video directly.
This is also,
and this is the part of the speech that was mentioned earlier, and mentioned by Chief Justice of India. Really, the importance of and the future of mediation really relies on improving the standards and quality of mediation, and this includes raising the bar for the ethical standards for mediators. So I'll now go on to talk about Singapore Convention, the importance of ethics and how it has been hard-coded in the treaty text itself. And I'll share a bit about the Singapore Convention on Mediation. It is a framework for international settlement agreements resulting from mediation to be recognized and enforced across jurisdictions. And before the Singapore Convention for Mediation was entered into, mediation was not taken seriously as a method of dispute resolution, as there were issues relating to enforceability. But since then, the Singapore Convention has been a game changer in two main ways. One is that it says that mediation is effective and is here to stay. And number two, the enforceability issue is now addressed by way of the multilateral mechanism provided in the treaty itself. And as evidenced by 46 countries signing on the opening day, which is a record for any UN treaty, this is a very important piece of treaty. And to date, 54 countries have signed on to the convention and 6 countries have ratified. The latest being Brazil just about a month ago. So as the Chief Justice of Singapore mentioned, with time, the Singapore Convention will become as influential and as widely accepted as the New York Convention, which governs the enforcement of arbitral awards in more than 160 countries. So ethics has become quite important, and this can be seen in the text of the Singapore Convention. And by way of example, you see here Article 2.3 of the Convention defines what mediation is. And this says that it is important that third party neutral has no authority to impose a solution for the parties to the dispute. And this highlights the voluntariness and self-determination of disputing parties in convening a mediation. And if a mediated settlement agreement is obtained improperly or unethically, then it can be rendered unenforceable under the convention. And you can see here Article 5E of the convention. It highlights one of the grounds for the refusal to grant relief. If there was a serious breach by the mediator of standards applicable to the mediator or the mediation, without which the breach, that party would not have entered into the settlement agreement. And this is important. It simply says that if there was a breach and you can prove that there was a serious breach, then the settlement agreement would not be enforceable under the convention. The second ground here says under Article 5F, where there is a failure by a mediator to disclose to the parties circumstances that raise justifiable doubts as to the mediator's impartiality or independence, and such failure to disclose had a material impact or undue influence on a party, without which failure that party would not have entered into the settlement agreement. Again, the settlement agreement under such circumstances can also be rendered unenforceable. So this really underscores the importance of ethics in mediation nowadays. I'll go on to discuss more about SIMC and the role of a mediation center in maintaining ethics. Just firstly, a little bit more about our mediation center here. This was established in November of 2014 pursuant to a working group recommendation by, among others, the Chief Justice of Singapore and the Minister for Law then, and current Minister for Law, Minister Shanmugam. And this is a not-for-profit center aimed at promoting mediation and international commercial mediation in Singapore and elsewhere. So just some mention about our services. We provide case management, end-to-end support for parties. We assist in the appointment of mediators, and we have on our panel over 70 international mediators coming from more than 17 jurisdictions. We also administer COVID-19 protocols, and these are basically our lower cost service that is provided during these difficult times in COVID. We also have our mediation arbitration protocols with the Singapore International Arbitration Center. And the other stuff that we do here at SIMC is in thought leadership, and that relates to the promotion of mediation. A snapshot of some of the cases that we manage. So to date, more than 170 cases with a total dispute value of more than US dollars 4.4 billion. And we see settlement in about 7 to 8 cases out of 10. And this is quite an achievement that we are proud of. And on the right, you can see the composition of our users, our top overseas users. And this really underscores the importance of our services, which we work very hard to ensure quality and standard of mediation for our parties. And we cannot do this without maintaining strong ethical standards. So how SIMC upholds ethical standards? So firstly, on confidentiality, we facilitate confidentiality of the entire mediation process. This means preserving confidentiality as against third parties and communications such as those for the mediator's eyes only. So this was elaborated by my colleague earlier. The second point, second C, is that we assist with the appointment of mediator and we are transparent about the process with parties. We also act swiftly to act on conflict issues so that mediation can proceed seamlessly. The third C, which is communication, we facilitate communication between parties where they are often acrimonious. And this is to ensure transparency and impartiality so that parties have the benefit of full end-to-end support, where in a dispute, they will not even be talking to each other. The third role that we play is the role of a case persuader. And where one party does not agree to mediate, we can connect parties and help explain the process to the parties to engender trust in the mediation process. We also help with the mediator appointment and the arrangement of logistics. And on the fifth C, Code of Ethics, this is something that governs the conduct of SIMC mediators. And this is really an extra layer of check and balance that we provide for our mediations. And on top of that, we also have an agreement to mediate that enforces confidentiality undertakings and other obligations. So I'll highlight now some of the experiences we have at SIMC that really flashes out certain ethical issues. So in the case of the one-party mediation, as we will call, this was a case where one party asked for mediation simply to fulfill a contractual obligation, despite the other party not consenting to mediation. So this was a straightforward issue of voluntariness. And a party can always choose to participate in the mediation or not. As a center, we will not be able to facilitate any mediation where there is no consensus. And the other example of the unrepresented party, this was a case where one party's lawyer discharged himself one day before the mediation, and this litigant in person turned up for the mediation on his own against the other party and their lawyers. So here there is an issue of informed consent and self-determination. At SIMC, we had to ensure that the unrepresented party has knowledge of what he is entering into, including the process of the mediation and the agreement to mediate that he has to sign. And at any time he was able to, he understood that he could withdraw from the mediation if he was uncomfortable. But in any event, this litigant in person decided to proceed. In the third example, we share this was a cross-border case between a Japanese and an Indian party. Co-mediators were appointed for this cross-border, cross-cultural case. And in this case, one party wanted to dictate the process. He set out the procedure for the mediation, how he and his clients think the mediation should proceed, what to submit to the mediators, who speaks, when and for how long, which mediator to speak to which party during the mediation. So this was interesting as there was a Japanese mediator as well as an Indian mediator appointed for this case. And the Japanese party only wanted to speak to the Japanese mediator. And we explained to the parties together with the mediators that there had to be consensus and parties must equally feel that they are able to exercise and protect their right to be heard. And I go on to talk a bit more about the online mediation process with SIMC. And this is really because online mediation has become commonplace nowadays in the COVID-19 environment. It is much easier now to circumvent ethical conduct with the use of technology. And at SIMC, we take extra measures to ensure that confidentiality is protected and not breached. So, for example, we use our preferred Zoom video conferencing platform to conduct our mediations. There are certain safety features using this platform. We will conduct verification of identities of the parties before the mediation to ensure that there are no unauthorized attendees. And thereafter, we secure the rooms, we lock the meeting to ensure that no one else can enter throughout the process. We also conduct an administrative briefing, remind parties that there should be no unauthorized recording, no one should be under the table, behind the wall, listening into the mediation where there is no authorized access. So this is part of our end-to-end technical support during these online mediations. Also, in terms of the signing of any settlement agreement, if a settlement is reached, we also assist parties in conveying drafts and helping parties put their signatures on the agreements when one is signed. And then I move on now to a case study, a Singapore case study reflecting some key issues that mediators face in mediations. So this was a case where a party went for mediation against another side without representation. So the other party, they were themselves lawyers and they were represented. So at the end of the mediation, a settlement agreement was entered into, but thereafter, so under the settlement agreement, the defendants to the suit agreed to pay a certain amount, and upon payment, the plaintiff was supposed to withdraw the two suits that were filed in court. The payments were made. However, the plaintiff did not withdraw the suits as agreed, and as a result, the defendants decided to apply to court to strike out the suits under the settlement agreement. So they were successful, and the plaintiff decided to appeal against this decision on two main grounds. Number one, that the settlement agreement was signed under duress, and number two, that the settlement agreement was invalid as she was incapacitated and did not understand the contents. In this case, the appeal was unsuccessful. And the key issues are really, number one, the power imbalance. This lady, Madam Chan, she was unrepresented, and the other side had lawyers representing them. She argued that this caused pressure on her to enter into the settlement agreement. On this issue, the court did not agree and felt that there was no evidence of pressure. She could have raised her concerns during the mediation, but she did not do so. And the second issue relates to the co-mediators' independence and neutrality. And in this case, two co-mediators were appointed to mediate the dispute. The lady felt that she was pressured to accept the settlement offer because the co-mediators told her that the case, if not settled, would go back to court for trial. And her argument, again, in this case, did not stand. The court said that there was no reason for anyone to feel pressured by the mediator's actions, and as a result, there was no undue pressure. And the third issue relates to voluntariness and self-determination. She could have addressed her concerns at the mediation, or even withdrew from the mediation, but she did not do so. And this was mentioned by the court that she should have done when during the mediation. If she had concerns, she should have raised them instead of raising them belatedly at this stage after the settlement agreement was entered into. So these are some of the key issues that mediators face during their mediations. So I'll now pass the time on to Sid to share more about his experiences and some India case studies.
Yeah, thanks, Shikai. So like so I'm sure most of you would know about this case, Motiram and others versus Ashok Kumar. It's like, a perfect, you can say, example case of the Supreme Court of India. So basically, like, just quickly, if I may take you through the facts, the Supreme Court had referred this matter to the mediation center to attempt to resolve it. Subsequently, like, when the mediator submitted a report to the court, various settlement proposals were, like, it mentioned various proposals that were made by the parties, among other things. To that, Supreme Court stressed that, mediation proceedings are strictly confidential. And it stressed, like, it was of the view that any disclosure of the happenings in a mediation proceeding destroys the confidentiality of the mediation process. So even in practice now, we've seen where, like, not a lot of information is written in the settlement agreement, and it should not be so descriptive. Rather, only the important points should be mentioned. And if a mediation is a failure, a lot of times parties come and, like, request that why don't you write the reason as to why the mediation was failed, but it's not required. And this case could be a guiding principle to that. Similarly, in the second case is also about maintaining the confidentiality. Next, Shikai, where in this case, Rama Aggarwal versus the PIO. So the public information officer in this case went to the Central Information Commission to get details or details about a mediation that had taken place before the Delhi State Legal Services Authority. And this application was filed under the Right to Information Act. But however, it's important to note that the Information Commission observed that information regarding negotiation, mediation, conciliation, and counseling will fall under exempted clause of information of other spouse, being personal and given in fiduciary capacity, and no public interest is established in disclosure, while there is a larger public interest in protecting that information, as that would help mediation to flourish. Hence, such information shall not be disclosed. So I was just going through a question, like, what happens if if a confidentiality is broken? So, of course, courts are always there to protect your rights. And of course, there are rules, and you can terminate the mediation, go to the courts. There could be damages that could be awarded. There are many things possible, depending upon the rules, law of the land. So yeah, these were the two cases, and Shika and I are done with our presentation. But and I think now we are open to questions. And Reema, if you could guide us. Yeah, thank you. Reema, you're not audible. So I think, Reema, we're still not able to, yeah. But meanwhile, Reema is trying to, like, fix her audio. If there are any questions, we are open to that. I think Reema had prepared some hypothetical scenarios, but I'm sure we'll go to that. But yeah, Shikai and I are open to questions.
Hello?
Yeah, she's back.
Now? Hello?
Yeah, hi Reema, you're audible.
I'm sorry, I don't know, there was some technical problem. I'm so sorry. So first of all, I would like to thank Siddharth, to you and Shikai for such a wonderful session and taking us and enlightening us rather with regard to the Singapore Convention and the role Singapore Mediation Center is playing in maintaining these basic ethics. Now, as we have discussed, I'm going to invite both the panelists for a panel discussion, and which I will be raising some hypothetical cases or circumstances, and then we will discuss on that. Meanwhile, I will be requesting all the students and participants, if they want to ask any questions, please write them in the chat box. And if they have any views on the ethical dilemmas which we are discussing, please write in the chat box only. And then I would like to read from the chat box and keep on asking such questions from our panelists today. So the first situation I would like to discuss. So are you ready, Siddharth?
Yeah. Yeah.
Okay, great. So the first hypothesis question, keeping in mind, I think we will be able to take only two situations, because after that we will be having our question and answer session also. Great.
Yeah.
So the first situation I would like to discuss is with regard to the conflict of interest. Okay. So for example, if a mediator is on the verge of settling a matter, and the matter is a very complex matter, and realizes at the end of the mediation later on, before the settlement has been drafted, that he is distantly, related, or he knows one of the parties. Okay. Now he is also aware that no one else knows about it, and there is no possibility of it being known to anyone at later stage also. What would a mediator do, keeping in mind the principles of being neutral, impartial in the mediation? Yeah, over to you.
Shika, you want me to go ahead?
Sure, you can start first. Yeah.
Yeah. So see, as I had mentioned in the very beginning, it's a very simple, and I use that personally, test, that headline test. Just think about it. How are you going to feel if that comes in the newspaper tomorrow, like, about that potential conflict? But there are, that could be one, but simply, like, the best option could be to disclose it to the parties. And because see, again, like in case of conflict of interest, voluntariness also plays an important role, because if you disclose it to the parties, maybe, like, it's on them to decide whether they want to continue or not. And in case the situation has become more complicated, you can always turn it down or terminate the mediation. Yeah.
Okay. Because do you want to add something on this?
Yeah, and I agree with Sid. And then the other thing, based on my little experience with SIMC, what I heard some mediators do is this is really quite simple. They normally say that if there's a question on whether something should be disclosed to the parties, then you should always disclose it. If in doubt, always disclose and make sure that there's no ambiguity with respect to any conflict of interest issues, because it can really derail the outcome, the settlement outcome, and there's no amount of money that is worth that kind of trouble.
So, what should be like? This is the answer will be different. I'm just asking if the mediator gets to know about at the initial stages of the mediation, because if he is getting to know about it in the end of the mediation, he has already, conducted so many, sessions with the parties, and they have also given their so much time. Now they are at the end of everything. So, will your answer? I would say, would your answer would be different if it is happening at the beginning of the mediation? And the first session itself, or the answer will be same?
So
because
I think
in the second situation, already the time and money has been invested by the parties.
Yeah, exactly. So that's when, even in both the situations, I will consider first disclosing it to the parties, right? It's okay to be, and that's what the process of mediation is. Everyone is supposed to be open and as candid as possible, so that basically be comfortable. So I'm sure, like, there could be a situation where in the end, time and money and, like, it has become more complicated. The easiest thing is to inform the parties. If at all, as I mentioned, like, I'll be repetitive, if at all it's too complicated, then you can just terminate. You can seek advice, and there is no harm in disclosing it to the parties, right? Because it's their mediation.
Yes, I would rather like to, in brief, tell about a very small incident which I also faced in one of the mediation in which I was doing in Supreme Court of India, where the parties came to me on the first date, and they both were sitting in front of me. I could, feel that I have seen one of the parties somewhere, but I was not able to recall where I have met them. Who are they? One of the female, I was not able to understand. So what I did is I openly asked in front of everyone
that, ma'am, I feel I have seen you somewhere. Can you please tell me that whether we have met somewhere or not? Or, so she then smiled and then she told me that few years back she came for some case to me. And in this case, what happened is the husband, he was so happy with me. Rather, he said, ma'am, by asking this question in front of me openly, rather, I have more trust in you now. Because after that, I asked him, that still you want me to be a mediator? Otherwise, we can have a change of mediator also. So he said, no, ma'am, now rather I trust you more than otherwise I would have trusted you. So I agree with both of you that such disclosures would definitely enhance the trust building between the mediator and the parties. So I think I can have one more ethical dilemma question for our discussion, then we'll go to the question round. Now the second situation is with regard to the power imbalance monitored by the mediator. Well, I will give the situation is that if A is represented by a very young lawyer who is not having much experience on one hand, and B is represented by a very big law firm and a team of lawyers, and mediator notices that A and his counsel, they are not able to understand their situation in the case properly, especially in the light of some new judgment or some change in the law. And while B is very much aware of this and is exploiting this knowledge in favor of his client, how can the mediator approach and handle such situations?
Shika, you want to go ahead or should I?
Yeah, feel free. Sid.
Okay. So yeah, there are situations where there can be power imbalances. Of course, it's the mediator's duty to step in and try to balance it out. Now, I do not have a perfect answer because it depends from situation to situation. But I can help you with an example. So I remember there was a mediation. There was a mediation going on where it was between a party that was just a distributor, like a distributor in the state, and another party was one of the biggest cement manufacturing companies in India. In that case, of course, there was a power imbalance. It was obvious. Another point on that was the distributor was a woman, and she was not assisted by anyone, neither an advocate, only her, I think some office boy used to come with her. And here with the company was assisted by the general counsel, and like, you know, he had a bunch of juniors. So of course there was a power imbalance there as well, psychologically as well. In that case, what happened, the mediator had it was a tough job for the mediator to actually try and balance it out, where we noticed, I was a center manager there, so I was privy to those proceedings. We noticed that the mediator was constantly having caucus sessions with the distributor and trying to explain, like, not of course giving out suggestions, but trying to make her comfortable. In that case, something surprising happened, which we got to know later stage, and it's altogether different topic. But that lady, she kept her iPad in the main mediation meeting room with the recording on. And while she was in the caucus with the mediator and the discussion that was going on with the big company, she knew, like, you know, even those, so they, again, like in that case, of course, it transitioned to a confidentiality dispute. I'm sorry to, like, you know, just deviate from your question. But I'm trying to explain, one should always judge it with the situation.
Okay. Shika, you want to add something on this?
Yeah, I think, yeah, that's very interesting. I've also seen some cases pan out in this way before. And I think maybe the best way to not address but deal with that issue is to conduct reality testing. I think, but this could go both ways. You know, so in the case of the case study that I mentioned earlier, the reality testing was taken as undue pressure by the party in the end. There's really no good solution to this, I suppose. But what do you think, Reema, as given your experience in having done so many mediations, I would actually like to know how you would address this problem.
So definitely as mediators, we cannot give them suggestions, legal suggestions. Yes, as I saw somebody has asked this question in the chat box also. But yes, I would like to say that I'm answering that question of some student also, that mediation has to be according to the law. Mediation agreement cannot be beyond the law. So there was some question, and I think that student can understand because I'm not able to read his name again. So but definitely in our when we are doing our Vatna, I think when we are looking at the best assisted agreement, at that time we can see how we handle that situation. And in case if at times we have seen that one of the party is having a lawyer and another one is not having a lawyer with them, and then that times they have an objection that ma'am, please tell them that they are also lawyers should also not be there. Or at times, as a mediator, you feel that that person will definitely will not come without his lawyer and we cannot push them. Then we can give suggestions that, okay, you also bring your lawyer so that you feel you are at par with each other. So this is how, depending upon situation and circumstances of each case, and we can have, I would say, number of questions, and rather we can go on for another 2 hours if we want to discuss these things. But keeping, a paucity of time, and I would say there is no right or wrong answer right now here. The reason actually we had this panel of discussion is basically to give a food for thought for everybody, that these kind of situations arises or these kind of dilemmas arises. So that is why I think we had this panel discussions, and there are actually number of situations we can discuss on this. But since due to paucity of time, we have to start our question and answer round also. So I would like to take the questions which are there in the chat box from the students. The first question is, what remedies, it is from Dr. Vikas Sharma, what remedies are available to a party if the mediator breaks the confidentiality code or ethical code?
Well, to answer your question quickly, it all depends on as I said, there are always options with the land of law. You can always approach the court can step in, and it depends, again, it depends under what country you are in or what law you're in. In India also, I think damages could be awarded. And yeah, even in many acts, for example, even in, I can just, from the top of my head, I can think of Information Technology Act, which also talks about confidentiality. So there are rules prescribed. Similarly, as I had mentioned about Section 75 of Arbitration Act, and also there is Delhi High Court mediation rules. So you can always approach the court.
Okay, and one of the next question is, when in doubt, that solution is disclosed irrespective of its time of occurrence. Okay, this is a suggestion given by somebody for our panel discussion with regard to the confidentiality by one of the students. Okay. That irrespective of the time when we were discussing, so it is these are the views of some of the students. But another question is, how can confidentiality in a community mediation maintained? Well,
that's a good question, and I think if we have, because we also have many seniors, I don't want to just jump and show my competence, because I've been involved in commercial mediation, so I personally do not have any experience in community mediation. So I would request if any of the seniors here present, or any of the other would step in and help out.
Okay, so community mediation, I would say.
I think it's more like lok adalats, community
kind of a thing.
So, so lok adalats do not involve confidentiality. It is also written in the manual that is given by the Supreme Court of India, where they have mentioned, there is a table, I remember, there's a specific table about mediation, lok adalat, and I think another mode, where lok adalats do not have the ambit, they are not under the ambit of confidentiality.
And if mediation is happening, I would say, whether it is community mediation or any kind of mediation, the confidentiality will remain the basic essence of mediation.
Yeah, obviously.
Whatever kind of mediation it is, So there is no difference if it is an international, national, community, any level. we cannot, let go the confidentiality, neutrality part. They are a basic part, or I would say the core principle.
Pillars of the process.
Yes, yes, I agree with you. Now, one of the question is, I think this question I was answering when you asked me the question was, how can, just a minute, yeah, since mediation can be since mediators can be subject matter expert also, how important is the knowledge of law for a mediator? For that, I was answering meanwhile also that mediation has to be within the four corners of law.
I personally, being a lawyer and a practicing mediator, and of course I'm way junior to all the persons who are here, but as I personally believe, and it's also an international practice, that non-lawyers can also be mediators, and in cases it has turned out that non-lawyers are actually better mediators. I'm not saying that because I'm personally also a lawyer. Why? Because see, a mediator, for example, now in international mediations or even in commercial mediations, you need a subject expert. You are not going to find a lawyer with all the expertise. You need to have a person who is also from a different sector, but a trained mediator. So one thing here, my suggestion is that, according to MCPC rules, only lawyers can be mediators in India. I believe that should be changed. Of course, different subject experts could be a mediator, and in the process of mediation, especially when the mediation is institutional, you always have an option of having an expert. It could be a legal expert if the mediator is not well versed in law, or it could be a subject expert if the mediator is a trained lawyer. It always depends.
So that I would like to add one more thing with you, is that definitely mediation settlement agreements cannot go beyond the law. One is very sure. And secondly, as you are saying that if there can be mediators, it is not, there are a lot of people becoming mediators who are not lawyers. But definitely in such cases, there are co-mediators to help them that the settlement agreement should be as per the law. So that is why at times at a few mediators in commercial matters also, other way also they are having some people who are who are having expertise on that commercial part of the litigation. If suppose if it is I would say IOC matter, and also a lawyer is not aware about the Indian oil policies. I was doing a matter, so I needed a person from their office who had gone through some mediation training to act with me as co-mediator also. So in such cases, if the person is not having the knowledge of law, then he should consult or keep somebody as co-mediator.
Obviously, that's why the legal
agreement should be enforceable in the court also.
Obviously, that's why the legal expert, and Reema, I've done way less mediations and I've experienced way less experience than you, if I remember. But I have personally not come across a case where a settlement was even if the lawyer was even if the mediator was a non-lawyer, he did not have that basic idea of what is legal and what is illegal or what is not under the ambit of law. One, and the most important thing, criminal cases or cases which are are criminal action, they cannot be mediated. So, and mostly what cases are mediated could be domestic or commercial mediation, right? In those cases, the question of legality, I think, is very less, could be just in 1 out of 10. And in those cases, of course, you can have a legal expert. Similarly, if you can have a different subject expert, if it is required. Yeah.
So for example, if it is a matrimonial matter, and suppose the person who is handling has no knowledge about the matrimonial law, for example, and she gets the party into an agreement that they can go for mutual consent without having any knowledge, that they have to wait for 1 year period before they go for mutual consent. So then the agreement is...
In that case, I'm sorry to stop you.
Against the law itself. So that is why,
mediation is I'm sorry to interrupt, but mediation is, I think, beyond law. Of course, if it's a domestic mediation and why do you mediate a domestic or a divorce case, right? To help the parties to reconcile. And if they are ready to reconcile, why will a court or law stop them? And if they have to separate, of course, then the mediation fails, right? So where is the question of law? Where is the question of
our settlement agreement? But our agreement should be according to the law. Then our agreement should wait for 1 year period before they move for first motion. Or our agreement should be, the person should be aware that 498A case cannot be withdrawn. It has to be quashed.
Makes sense.
So
Yeah.
these are the basic knowledge a person. So this is the answer to my question somebody was asking. Is with regard that whether a mediator, so a basic knowledge about the subject is, and rather I would say this is one of the ethical dilemma also at times that when a matter is marked to a mediator. Suppose I am a mediator who is only doing matrimonial cases, and if I am a marked a matter which is an MACT matter, motor accident claim, for which I need to have more knowledge or a labor law matter, then I should be first as a mediator. It is very important for me to see whether I am justified in holding such mediation because I'm not very conversant with those laws. So this is also one of the ethical dilemmas, or it's very important for all the mediators to follow these kind of principles.
That's where competence comes in. Yeah.
Yes, it is very important. Yes. Let me check any other important question. Just give me a minute.
I had come across an interesting question as to how do you maintain private sessions, or how do you do private sessions in online mediation? So just quickly answer you. Zoom has this possibility.
I just tell you. So we are conducting our online mediations either on Cisco WebEx and our Supreme Court we are doing on Video Connect. So in Cisco WebEx, there is you can, send parties to,
in the room.
I don't remember that word, that
room.
waiting, lobby. You're sending one of the parties to a lobby. And then after, the private session is over, then you can add them back. And in Video Connect, what we are doing is, we are asking one of the parties to leave the mediation. And we tell them that once we are over with this separate session, we'll give you a call or or there's a WhatsApp group in which we tell them to come and join back. So that is how we are handling those separate session in online mediation.
Yeah.
Okay. So let me check what is another question. Give me a second. So what about the ethics of advocates? What about ethics of advocates of parties? Okay. So the question is basically with regard to the ethics of advocates, not with regard to the ethics of a mediator. Your lawyer is not interested that you should settle your matter in a mediation, because definitely it's going to impact them too. So what should you do in such circumstances?
Yeah, and I'll also answer another question here. Someone had asked, what is thought leadership at SIMC? So in this case, it is important to have a mediation advocacy. The advocates or the practicing lawyers should undergo mediation advocacy, because that actually helps in understanding how to prepare for a mediation. What is the difference in preparing for a mediation and a trial? Generally, what I've seen, a lot of lawyers, they prepare for the trials, but they do not prepare for a mediation. So there is always a difference in how you deal with both the things. So of course, it's very necessary for all of us lawyers to undergo a mediation advocacy workshop or training, where it's not really training you as a mediator, but giving you or trying to make you understand how to make your client's case best while representing him in a mediation session, and how to also make or regain your how to shoot your career in mediation by learning those advocacy skills. Yeah, so that's my answer.
Okay, when two students actually have been reading side by side, so one of them was asking that what if a mediator is not a lawyer, as you said, Siddharth? Then how will he handle the situation if the parties are having lawyers with them?
Can you please come again? I'm sorry.
So what if the mediator is not a lawyer, but the parties are coming with the lawyers? How will he handle this situation?
See, again, if it's an institutional, he can always have a legal expert with him if there is a complex situation of law involved. But I don't think so it will be a problem, because if the parties are voluntarily coming for mediation supported by their lawyers or their counsels, they also have to come with that mindset to get a settlement that is win-win for both. And I'm sure it's not going to be very difficult for the mediator, because the mediator's job is to facilitate the mediation, rather give suggestions or impose any decision to the parties.
Okay, one of the another thing is that it is said that can a mediator appoint or seek the help of an expert from some other field during the course of any mediation, if it is a technical matter?
Yeah, I'm sure that's where the experts come in, and that's where again, like I'm going to impress upon institutional mediation, where of course there are experts who are empaneled, and like you can always turn to them, maintaining the
And
ethical.
yeah, one of other questions is can banking matters be mediator even if one-time settlement is possible? Yeah.
I didn't get that question.
Can banking matters can be mediated even if one-time settlement is possible. Basically, one-time settlement is possible in lok adalats and all.
And that becomes conciliation.
That becomes that's what, yeah. So I was also about to say the same thing.
Yeah.
And then one Niti Bajaj is asking, mediation is beyond law. That is why it is least scope for creative solutions, which can never happen in a lawsuit. Beautifully said, sir. So she's complimenting.
Oh, thanks a lot.
Okay, so I think we are not left with much of the questions, and we are finishing within our time, 6:20. So anybody else wants to say anything or to add anything, or any one of our seniors present here, or anyone, any student, just for 5 minutes.
I'd like to just ask, what is the scope of a non-lawyer? What are the avenues for a non-lawyer in mediation?
So first of all, they need to be trained as a mediator. When you are trained as a mediator, you always have an option to empanel yourself if it's if it's accredited. This is of course outside India, because as I said, in India, non-lawyers are not recognized as mediators as per the MCPC rules. But there is always a possibility, and I personally have seen, I'm sure Shikai can also come in here and give you examples as to how non-lawyers are fantastically mediating cases. Agreed, the settlement or mediation should be under the ambit of law. But I personally have never come across any complicated situation where a law is under question. And even if it is, there are always legal experts to help out. How to do that? It's just get yourself trained. They should get themselves trained. And in the international market specifically, there is a lot of demand for subject experts to be mediators. Same as it is in arbitration. Yeah.
What about SIMC? Are they having any options, any avenues for non-lawyers?
Shikai, would you like to take that question?
Yeah, just to add, the short answer is yes. There are mediators that are not legally trained, and in mediations, parties select their mediators. So of course they agree to use any particular person for mediation, and they trust that a certain person can do the job. Of course, the lawyers representing the parties also assist the mediators, not to forget that. So if any legal issues, the mediators can also seek the assistance of the mediation advocates in such matters.
Thank you. Thanks.
Okay,
Reema, can you hear me?
Yes, sir. Yes, sir.
Okay, Siddharth and Shikai and Reema, I think a wonderful session. But apart from that, I want to compliment Siddharth on something he said. And I feel that, ethics with a mediator, of course, lawyers, of course, if he's a lawyer, he already knows what is ethics. But even as mediators, I think what Siddharth said has a lot of value. And that is that he says, if he does something, which if it is reported in the newspaper in the headlines on the next morning, what would he feel like? Now, I feel it is a conscious effort on the part of the mediator to be neutral. And also, we find very often there are challenges subsequently to awards also, where people say that the mediator was linked to a law firm or was a part of a law firm where this one of the parties was a client. So I think you may have as many rules as you want to have, but it depends on the persons. And it is a personal thing that if you want to be neutral and you are conscious about the ethics that you want to impose. Thank you very much. Thank you. All of you have done a wonderful job.
Reema, I wanted to ask one thing. This is Manjula here. That is in continuation of Suruchi's question. I want to ask that as we are discussing now that non-lawyers should also be, they can also be mediators. But if they are mediators, they are not lawyers, so they don't have any legal knowledge. So will that not be treated as a expert? Or will, because of the lack of knowledge in law and all, they are knowledgeable in their own subject, but not otherwise. And for a legal this negotiation and settlement, which has to take place in the end of the day through the court, don't you think that that may be a barrier for that? I just wanted to ask.
In simple words, Manjula is basically saying the enforceability of the agreement will be in question if it is not within the four corners of law.
That may not be as per law. So I want to ask whether that not be treated as an expert only?
Yes, yeah.
I get your question, and I think I'm going to answer in two parts. So yeah, of course. So it's not only that he'll be considered as an expert because he will be a trained mediator. I'm sure, like, you know, because we undergo 45 hours of training, that's how we become a basically trained mediator. Similarly, and when you are, I'm sure, when you are training yourself as a mediator, the law subjects are fairly less, and there is more discussion on psychology and conflict of theory and, like, you know, what one should do. So while a non-lawyer is acting as a mediator and there is a question of law, a legal expert can be, like, you know, an advice from a legal expert can be taken. Similarly, as you would take an advice from an engineer who's an expert. So similarly, we should treat in that way. And I would like to comment one thing, and this is just a food for thought for, like, you know, all the seniors here, that do you really need enforcement of mediation settlement agreements? You don't, because the parties have voluntarily agreed to it, right? So why do you need to enforce it?
You need a time.
Yes.
That's there. But in that case, the mediation was not successful because the parties had no intention to settle the matter. If they really had...
It is not also at times they're ignorant about something, you know. At times, due to some ignorance, it can happen also. No? They are not aware about something.
Also, Siddharth, I want to add that maybe after some time, they change their mind and they want to step back or step a little forward. So it is always good that we transform them into an order of the court.
Yeah, obviously. And I think as per Indian laws, a mediation settlement agreement is treated similar to a conciliatory order or an award. And after the UN convention, the Singapore convention, it has made it easier for even the cross-border mediations to enforce them in the respective countries. Correct. So that option is always there, but this was just, like, you know, food for thought that you actually don't need
mediation. So that I would like to add one more thing. At times what happens, you know, when parties, they write the settlement and then they go back home and then they are told by somebody else that it is not the right settlement or you must have agreed to pay less or something, and then they go back to the court and then they tell the court that the mediator has not informed us properly and the things comes on them. So there it's actually a lot of things we can discuss, but I think we are...
I think as Shikai has informed us that this convention of Singapore is been a very, one of the best things that have happened in the near past. And one of the basic reasons was its enforceability that it has now brought about. We are really, really happy about that. Thank you.
So that's, you know, enforceability
send it by
is a
email
very
as well
important
as
thing
WhatsApp
in our
also.
settlement.
It's okay?
Hello.
I'm sorry.
Sir, Gautam has vacated the house. Yes, just...
I think everybody should mute themselves. It's a request. I'm so sorry. Okay, and one last question. I was just reading. Somebody was asking me, I think Shikai and Siddharth, you are the right person to answer that, since you are doing a lot of international mediation. So at times, you know, if there is a language barrier and the mediator is supposed not, if mediator only knows English but the parties are, one of them is Japanese or somebody else. And at that time, we are having, some translator. So will it impact the confidentiality?
Shika, you want to go ahead or should I?
Yeah, maybe I'll just start first and you can add on. So, so I think if there's to be any use of translators, this would be agreed by the parties beforehand. And of course, the translator, or as with any third parties to the mediation, they will be bound by confidentiality clauses, confidentiality undertakings, even if they are not a party to the agreement to mediate. So all the third parties, including translators, will be bound by confidentiality.
So,
yeah, and one more thing, I would just like to step in and close this. Like, a lot of times when, again, impressing upon institutional mediation and especially cross-border mediation. So as Shika had also mentioned earlier, the parties are given an option to choose the mediator, like, as per their agreement. They are not, or in case they cannot, then the institution steps in and suggests them some mediator. And of course, like, in those cases, language can also be, can be taken care of, or co-mediators could be there. But yeah, that's what, and I think like there's no other question.
I'm sorry to be deviating back to my original question. Is in avenues and scope, what I meant was, is there any training in India for non-lawyers?
There are a lot of trainings for non-lawyers that is done, except outside of the MCPC. There are many training programs, and now it has become much convenient and more easier for people to get themselves trained as a mediator remotely. So they don't have to travel or anything. And they also get accredited after, if there is a quality assessment, like for example, SIMI or IMI, or the ADR group.
ODR and all. They're doing online.
ADR, yeah, but yeah. So so there are many trainings outside the ambit of MCPC that one can give.
Yes, which they are actually happening in online many times.
In India, I don't know, because ADR, ODR certainly.
Yeah, I can tell you.
That I know. Yeah.
Over the phone later on. I'm quite aware of it.
Well, there are many institutions that do that. Yeah.
Yes. With this, I think I would like, though it is a very interesting class, I think, going on, and we can spend more time, but we have to keep in mind the time of everyone who is there today. So I would like to end today's class by again thanking Siddharth and Shikai for giving their precious time and enlightening our students and us with regard to a lot of other things, especially about the Singapore Mediation Center, how they are maintaining ethics, and about the Singapore Convention and a lot of other things. Thank you so much, friends, for your time and for the knowledge you have shared with us. I would definitely say that it will help us aspiring students who are going to be future mediators to get the clarity. And on the basic, I would say, practicalities of the subject. Now they know that one need not to be a lawyer to become a mediator. And I'm also grateful to the Nivaaran Summer School team for making this class and the whole program as a big success. Wish everyone all the best and keep the journey moving forward. And tomorrow's great session, I would say, we will be having Ms. Gunawati Subramaniam from Malaysia, who will be educating us on online mediation along with its advantages and disadvantages. The session will be hosted by one of our very good mediators, Sangeeta Mehrotra. I would like to request to be there tomorrow also and get more knowledge, gain more knowledge about the subject. Hope to see everyone there tomorrow. Till then, a goodbye. Thanks to everyone again.